It is what is going on in Congress. So on March the 16th, 2021, which was just a couple weeks ago, there was a presentation in Congress for the Stronger Child Abuse Prevention and Treatment Act, which is a reauthorization of CAPTA, and it is H.R. 485, if anybody wants to look up and follow it. So it was presented by Congressman Scott from Virginia, and I have to say I am not exactly sure who that is. So
Bobby Scott, he's in the 3rd Congressional District.
What's the first name?
Bobby Scott.
Bobby
3rd
Scott.
Congressional District, Virginia. Yeah.
Okay, and is he Republican or
He's a Democrat.
Okay, so we have a Democrat, Bobby Scott, in Virginia. And also it was co-sponsored by, I read it in here, I'll come across it in a minute. Now, I'll tell you, it's also a bit of a challenge reading reauthorizations in particular because sometimes they read like this. It says, in subsection B1, by inserting early learning program and after including subsection C1C in clause 3 by striking and at the end. Okay, so you have to get past all of that. I see Maureen's like smiling, but you have to get past all of that and get down to see if you can figure out where they're really going with this. So the first section, it talks about fatalities and setting up a new tracking system where they have to do fatalities. I'm just going to kind of move past that one. We all know that's important, but when we're talking about child welfare reform, we're more interested in where they're going with their treatment and programs. So the next section, we start talking about that they're to do research and assistance activities, which is a little bit broader scope than the original CAPTA was, on an interdisciplinary program and longitudinal research. So one of the things, even when I first started reading this, that I was kind of noticing is really taking a look at a different kind of approach, which I was happy about. And several times in here, they talk about changing language. So they've changed some specific language about things being family-centered, about community resources, about how poverty is to be handled, and even how substance abuse is to be handled. So they're looking at these things specifically, and they're doing them kind of a little bit different than the general attitude, because these specific things were not really addressed under the original CAPTA. They sort of whisk over it and called it just generally child abuse prevention and treatment. And then what happened, as we all know, over the years and years and years, and how the agencies have created their policies and their investigation and their best practices, we know they're taking kids because they're poor. We know they're taking kids because of disabilities. We know they're taking kids because of substance abuse. We know that intramural exposure is like a done deal. You're going to like lose your kids. So this very interestingly addresses some of those from a little bit different perspective. All right, so, and I highlighted a ton of stuff in here, so forgive me while I sort of stumble over it, because I want to point out certain things to you. All right, now, so the research, they talk about grants to Indian tribes. Okay, over here, they are going to, part of the new CAPTA reauthorization is the establishment of a national child abuse hotline. So everybody may go, oh my God, this is horrible. But when you read through it, the purposes of the hotline are a little bit different. And what they are saying in this hotline, they're going to create a grant for this hotline, and they're looking for some type of an organization that already provides some kind of hotline services, such as perhaps suicide, or, I mean, that's the only one that came to the top of my head. But they talk about, let me get to the first part of this section. Okay, the professional development program for hotline personnel, including technology professional development to ensure that all persons affiliated with the hotline are able to effectively operate any technological systems used by the hotline. And then this is what's critical. The qualifications for hotline personnel include understanding the methods for the creation, maintenance, and updating of comprehensive list of prevention and treatment service providers, a plan for publicizing the availability of the hotline throughout the United States, a plan for providing service in non-English speaking callers, a plan for facilitating access to the hotline and alternative modalities, a plan for providing crisis counseling, general assistance, and referrals to youth victims of child abuse, a plan to offer alternative services to calling, such as texting, and those categories are part of that training. Now, of course, what struck me the most was having a comprehensive list of prevention and treatment service providers. So what we hope this is going to turn into, and as we get into this more, again, we're going to talk about those specific categories, but what we hope this turns into is a resource as much as, if not more, of a reporting. So, because we know, those of us who've been advocates or worked in it for a while, we know that there are parents who reach out because they have an uncontrollable situation and they end up being investigated. So they end up being the subjects of investigation because that is the modality that they work in, and that's their practice. That is their practice model. So I'm going to go down here as well, just kind of look again at the hotline. So then, of course, in this law, they talk about how to measure the performance and effectiveness of it, the goals, the dates, etc. So the national hotline is an important part of the new CAPTA. All right, the next section, it's called Section 106, is on grants to states for child abuse, neglect, prevention, and treatment programs. Now, up here is where we start changing some of the language of the law. Let me read this one. I mean, when we read this and then we think about the reality, we go like, okay, we hope this works, right? Here's what it says. Here's the language of it. Development and operation grants. The Secretary shall make grants to the states from allotments under subsection F for each state that applies for a grant under this subsection for purpose of assisting the states in improving and implementing a child protective service system that is family-centered, integrates community services, and is capable of providing rapid response to high-risk cases by carrying out the following. Number 1, conducting intake, assessment, screening, and investigation of reports. Number 2, ensuring that reports concerning a child's living arrangements or subsistence needs are addressed through services and benefits, and that no child is separated from such child's parent for reasons of poverty. Mm-hmm. Huge. Okay, this is huge.
That was huge, yeah.
Now, at the end of this, Representative Moore, and I'm not sure, I think she's California.
In
Wisconsin?
Yeah.
Okay.
Or Minnesota.
Congresswoman Moore last year had introduced a bill that was called Poverty is Not Neglect. And I will say, as a lawyer, I've stood in front of the Court of Appeals and I have said poverty is a social issue, not a reason to end parental rights. And they all just look at me with like eyes glazed over and like, you know, it's crazy. But Moore, Congresswoman Moore, had introduced a bill called Poverty is Not Neglect. And at the end of the congressional record, she does put an entry into the record where she says this is intended to integrate her bill, and she's very thankful for that. So, all right, hold on.
She is Wisconsin.
She's Wisconsin. Okay. Hang on.
I get confused because Amy lives on the line, but I've reached out to her office and the legislative assistant I'm already in touch with.
All right, creating and improving the use of multidisciplinary teams and interagency, intra-agency, interstate, and intrastate protocols to enhance fair investigations, I like that word, fair investigations, and improving legal preparation and representation. Now, again, this language from this perspective, you know, the states tend to mess the language up as much as they can, but the point about improving legal preparation and legal representation, we would hope, works for the benefit of the parent and the family as well. Establish state and local networks of child and family service providers that support child and family well-being, which shall include child protective services as well as agencies and service providers that address family strengthening, which is new language to CAPTA, parenting skills, child development, early childhood care, and learning child advocacy, public health, mental health, substance use, disorder treatment, domestic violence, developmental disabilities, housing, juvenile justice, elementary and secondary education, and child placement. So this is where I talk about now they're beginning to say, let's look specifically at some of those other of those elements. And then down here, Maureen, you'll like this one. Address instances of child abuse and neglect by incorporating evaluations that assess the development of a child, including language and communication, cognitive, physical, and social and emotional development, the need for mental health services, including trauma-related services, trauma-informed care, and parental needs. Yeah. That's, at least it's in the language, right? That's always
Let's hope it plays out and we'll influence how it does.
But you know, that's why it's so important that we learn the language, because you know, that's one of the ways that I help parents, and one of the ways that we strengthen parents is by knowing what the language is. Because you go into these cases and parents end up in these cases and they assume that the caseworkers in the state are going to follow the law and do the right thing, but it ends up they're just doing all this crazy stuff, and you've got to have that language. And I use CAPTA language sometimes, because I will say, just like reasonable efforts, and you know, in Tennessee they like to say, well, you know, under state law we don't have to do reasonable efforts, and I'm like, you know what, under federal law you always have to do reasonable efforts all the way up to the end of the child parental relationship. So yes, so we have that language. So we need to get this, you know, at first when I saw that this was a stronger CAPTA bill, I was quite anxious about it, but it actually has some good language in it. Oops, who is that? Somebody needs to mute out there. RMKC, can you mute your, oh, there you go, thank you. All right, the next one here, okay, ensuring child protective services is addressing the safety of children and responding to parent and family needs, which shall include A, family-oriented efforts that emphasize case assessments and follow-up casework focused on child safety and child and parent well-being, which may include ensuring parents and children undergo physical and mental health assessments. Now, we know the mental health assessments, I heard you guys start to talk about that a little bit this morning, can be you have to be very careful with those. And ongoing developmental monitoring, multidisciplinary approaches to assessing family needs and connecting family with services, including prevention services, organizing a treatment team with the goal of preventing child abuse and neglect and improving parent and child well-being, case monitoring, and differential response efforts. Now, again, we know that they take, part of my argument, even when I go to like my state legislature, is I'm like, the child safety narrative has exceeded the family strengthening, the family preservation narrative, which is why we got everything so twisted, and the best interest of the child kind of took over the whole best interest of the family. And I mean, I kind of read that into this, that this is now sort of the family strengthening, the family parent-child relationships. You know, we're now looking at, although they don't say it in here, but a little bit more of the best interest of the family than just trying to focus on child safety.
So Connie, may I ask, in your opinion at this point, are you seeing where the family first language and intent has to some degree informed the context of some of what you're reading in this reissuance of CAPTA.
Okay, so good question. So we know the Family First Act really had 4 pieces to it. The first one being the 12-month services prior to removal, which is the one really kind of most critical to us, and the kinship. So and again, maybe I'm optimistic, maybe I'm trying to read too much into it, but what I see in here is an incorporation. Now remember, CAPTA is primarily Title IV-B money, not Title IV-E money, right? So primarily your CAPTA funds are coming out of B, which is a limited resource, so we have to keep that in mind. But they do talk in here, there's a little phrase, and I don't know if I can find it, there's a little phrase in here where they do mention accessing Title IV-E money. So, but remember, under the Family First Act, you can access Title IV-E money for the services 12 months prior to removal. So,
and that is state reimbursement money. It's not money that can be obtained from the feds to provide those services. So states need to have an adequate budget to provide those advanced services so that they can then get reimbursed for those advanced services.
That's correct. It is reimbursement. Mm-hmm. All right, let me So then there is also where there's a whole paragraph on educating caseworkers, community service providers, attorneys, healthcare professionals, parents, and others engaged in prevention, intervention, and treatment of child abuse, which includes, of course, they always put child safety. So the first one is child safety. The second one is approaches to family-oriented prevention and intervention and treatment of child abuse and neglect, early childhood, child and adolescent development, and the impact of adverse childhood experiences, the relationship between child abuse, domestic violence, and support for non-abusing parents, strategies to work with families impacted by substance abuse disorder and mental health issues, and, when appropriate, be coordinated with prevention efforts funded under Section 471 of the Social Security Act. Then down here, improving general child protective system by developing, implementing safety assessment tools, providing that such tools, protocols, and systems shall not authorize the separation of any child from a legal parent or guardian of such child solely based on the basis of poverty or without judicial order, except in the case of imminent harm. So that's the first time that's ever been in CAPTA.
Well, that's what they do in Florida.
That's the first time that's ever been in CAPTA. Okay, so let me move on down. So again, repeatedly, the next section is on eligibility requirements for Title IV-B and the state plan. Another consultation section in developing the state plan. The state shall consult with community-based prevention services, parents, families affected by child abuse. Yeah, they're supposed to be consulting with families, which they never do. Law enforcement, family court judges, prosecutors, etc. I want to get down to there is a establishment. Okay, so I'm going to go over to this one, which is Citizen Review Panel. Now, I think, Maureen, have you worked with your Citizen Review Panel?
I have. I was actually on the Connecticut Citizens Review Panel for 2 or 3 years. I've been asked to sit on it again, and I declined. A state who accepts Title IV-E funding in any form is required by federal law to have a Citizens Review Panel. Most states do utilize that, and they often screen who can participate in those Citizen Review Panels. Many states, I'm told, do utilize some of what that panel does, such as investigate programming, use best practice methods to investigate programming, and really drill down into the trends of certain child welfare programming to give recommendations to the commissioners. What I failed to see, however, is where the commissioners are required to implement any of the recommendations that the Citizens Review panels offer. That really they're offering suggestion and findings, but they are not viewed as something that the commissioners required to implement in whole or in part.
Wow.
They're also not made public. So the letter from the Citizens Review panel or report that goes to the commissioner is not made public, and that commissioner can respond to it in a politically correct way, but often doesn't do a whole lot with it. So, the value is in the pudding, right?
Yeah, and so let me ask you, is that recommendation letter, though, subject to open records request?
So, to the best of my knowledge, I have no idea.
Okay.
In Connecticut, it has not been made public, and we haven't challenged it here. Certainly we could. The panel I was on was in 2016, 17, I believe, and our first year we did a drill down into voluntary services, and what that report showed really compared Connecticut's work to New Jersey's work and a couple of other states. We used 3 different methods, and the commissioner at the time did nothing with it. The new commissioner, however, hasn't upon our recommendations and other work that we did, and we did in fact get voluntary services moved out of child welfare umbrella and over to a social services deliverable model. It's still in the works as to being as effective as we'd like it to be at serving the needs of the families we all work with. But we did accomplish something, but it took a few years and a change of a commissioner to do that, a change of a mindset, and a shift of an internal culture, even just 1 or 2 degrees to get that done.
Yeah, and thank you for saying that. And because part of the argument whenever I am speaking, even to officials who, think child safety is the ultimate and the reason we have CPS, I always talk about that internal conflict, and I say it's litigation, it's a litigious, it's an adversarial system, and it is in conflict with an agency that should be providing family services. So that's awesome that you were able to even get just that bit of a movement. And I recommended an advocacy program for Tennessee this year. We'll talk about more about that tomorrow morning when I talk about some state legislation. Okay, so going back to, go ahead.
Before you move forward, I just want to say that child welfare social workers are training really focuses on 3 bubbles: safety, well-being, and permanency. And whether a state puts one of those bubbles at the primary point of what they do influences all of what the culture, programming, and posture of the agency really flows to parents. So if it's all about safety first, everything's driven by safety or permanency. But when a child welfare agency puts well-being first, which it sounds like CAPTA is trying to shift the lens to be, there should be, according to those administrators I've talked to, there should be a greater emphasis on well-being of child and family, opposed to safety of child, permanency of child, which really leaves the family and importance of the family unit outside the conversation.
Right. All right, so this other in CAPTA in the state plan is where it says that there shall be provisions and procedures to require that a representative of CPS agency shall, at the initial time of contact with the individual subject to a child abuse or neglect investigation, advise the individual of the complaints or allegations made against the individual in a manner that is consistent with laws protecting the rights of the informant. Now, the reason this is important to me as an attorney, and I've seen a lot of things morph over the years, but when I would have a client call me and say they need DCS wants to talk to them, and they would come to my office, first thing I would say, because they always want to get you talking first, right? They want you talking first. So I would say first, and this is what every parent needs to know, this needs to be out there, is that you ask first what the allegations are. And so they would, first of all, probably 3 or 4 years ago, they would tell me exactly what the allegation was. They would be, the child was late for school 6 times, blah, 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 she doesn't appear to be dressed for whatever, right? A couple years after that, I would ask, what are the allegations? And DCS would say, psychological abuse. And I would say, that's not an allegation, that's a conclusion. And I would say, I need to know the allegations. And they'd go, that is the allegation. And I'd go, no, it's not. So you have to force them, not just to say, well, neglect or medical neglect, or you need to get them, because somebody who's reporting child abuse has to give the narrative. They have to give the details. And I know, because I have been in a situation where I have had to make a referral before over something that was very serious, and they ask for details. And so if you don't have the details, you're screened out. So parents are entitled to ask for the details. They should be asking for the details. And to get federal money, taxpayer dollars from the federal government, they have to provide that to you. Okay, so let's move on to, all right, as you can see here, I'm doing like one particular thing kind of out of a page because there is so much in here. So here's an interesting one. This is an assurance that the state has in place procedures for responding to the reporting of medical neglect, including instances of withholding of medical indicated treatment from infants with disabilities who have life-threatening conditions, procedures or programs, or both within the state child protective system. Now, when I read this paragraph, my antenna went up in that late-term abortions has been a topic of conversation throughout the U.S. and even infanticide. And who was it, Virginia, that allows for that, Miss Kimberly? Is it Virginia that allows for, after a baby is born with severe disabilities, the doctor and the parent can decide whether or not the baby lives?
Yes, correct. Yeah.
So according to CAPTA, that's not an option, that there has to be an instantaneous response by CPS. I was shocked to read this, but it is actually specifically included in CAPTA that there has to be a medical response to an infant born with a life-threatening illness.
Really?
Yes,
Wow.
yes.
Do you have a statute number on that one?
I'll show it to you. Well, this is the new bill. It is HR 485. All right, the next one that struck me, just talking about some of the programs. So again, part of the state plan, they have to have a description of policies and procedures, including appropriate referrals to child welfare service systems or other appropriate services, including home visiting services and mutual support and parent partner programs. Okay, so this is the first time ever that they have put into CAPTA even the slightest reference to peer advocacy, parent advocacy. So that is very important to me and kind of touches on the advocacy program that I'm going to tell you about tomorrow. Determined by a family assessment to address the needs of infants born identified and affected by substance abuse or withdrawal symptoms resulting from prenatal drug exposure or fetal alcohol syndrome, including a requirement that the healthcare providers involved in the delivery and care of infants notify CPS welfare system of the occurrence of such condition in such infants, except that, listen closely, did y'all just hear what I said? Okay, did y'all just hear what I just read? Because if not, I need to go back. This is a paragraph talking about fetuses who are affected by intrautero by drugs or alcohol, and it says a requirement that healthcare providers involved in the delivery of such infants notify CPS of the occurrence of such conditions in such infants, except that 1. CPS shall undertake an investigation only when the findings of family assessment warrant such investigation, and such notification shall not be construed to A, establish a definition under federal law that constitutes child abuse or neglect, or require prosecution for any illegal action. So, from my state perspective, where they're out snatching babies because and it can be a baby who's born perfectly fine, but let's say the mother during the course of her pregnancy had one positive screen or two positive screens during the course of her pregnancy, and then those prenatal records end up at the hospital after the delivery, and they go to the hospital and snatch that baby in 2 days. The other thing they're doing is they're doing tests on infants, newborn infants, that are qualitative only, which can show up for meth, and then it can be, unless they send it to the lab and do a quantitative result, it can actually be a Vicks inhaler or Sudafed, or it can be a perfectly legal methamphetamine metabolite, and they're snatching those babies. They're born healthy. There's no abstinence syndrome. There's no withdrawals. These babies, by all appearances, appear to be healthy, and they're still snatching them. So the way I read this statute is that there has to be some type of a family assessment to see if there is an ongoing risk. That's the way I read it. Okay, Bossy, can you please mute? Bossi. Okay, can you mute Bossy, Maureen? Do you know how to do that? No, not me.
Oh.
You muted me.
Can you unmute yourself? I'm trying to get that other one muted.
Okay, there I am.
Thank you.
Yeah. Mute this one down here.
All right,
Okay.
thank you.
All right, thanks. Okay, so I read this as a requirement that the state do an assessment for whether or not there's any ongoing threat of harm. I hope that's the way it turns out. I think that's something we need to follow up on and make sure of. But Kimberly, that'll be very important for you as well, right? With what you do, very important. Okay, so the next thing I wanted to bring to your attention is domestic violence services. So there's another section that's saying that the state's plan needs to include, and I have to explain to you another real challenge of reading the congressional record is all like section I, part 2, 7B, blah, blah, blah. So it's a little bit confusing me making sure I've got the sections correct. Okay, the state's efforts to improve appropriate collaboration among CPS agencies, domestic violence service agencies, substance use disorder treatment agencies, and other agencies in investigations, interventions, and the delivery of services and treatment provided to children and families affected by child abuse or neglect, including children exposed to domestic violence. And then policies and procedures regarding differential response as applicable to improve outcomes for children. All right, so again, some of these language, maybe I'm being too optimistic about it, but too many times victims of domestic violence have lost their children, either because they have to go to a shelter, and sometimes DCS has even said that the shelter is not an appropriate home environment, or when they get kicked out of a shelter, they don't have any place to go, they don't have any other family support, then they truly do become homeless. So it's trying to take away the incidence, I hope, of removal due to domestic violence. There's another section in here, this may not be important to a lot of people, but I found this interesting. The section is titled Public Access to Court Proceedings. It says, nothing in paragraph 2 shall construe to limit the state's flexibility to determine state policies relating to public access to court proceedings to determine child abuse and neglect, except that such policy shall, at a minimum, ensure the safety and well-being of the child. So there was some prior language in CAPTA about confidentiality of court proceedings and about state records. I have a feeling that there's been some complaints about people not being able to get their court records. And, I think they wanted to put this in here. I think they know they have to defer to the states on that, because technically when you get down to that court process with the states, it is a state function. But at least they brought that up and brought it to the attention of the states. They have panel. Okay, so here's an interesting section, which is brand new. Protecting against systemic child sexual abuse. I found this caught my attention. This is very interesting. So, systemic child sexual abuse is really sexual abuse within an organization that is not properly addressed.
It's foster care and adoption.
Group homes.
Well, I mean, there's been sports and other things, but
Yeah.
you're right. I mean, I don't know how far it's going, but here's what it says.
That's interesting.
Here's the way it
Church, Catholic.
Exactly. And here's what it says. The term systemic child sexual abuse means a pattern of informal or formal policy or de facto policy to not follow state and local requirements to report instances of child sexual abuse in violation of state and local mandatory reporting laws or policy, or a pattern of assisting individual perpetrators in maintaining their careers despite substantiated evidence of child sexual abuse.
Wow.
So this, it's kind of hard to see how far this covers, but this is a whole new section of CAPTA. And where do we see? I'll tell you just some of the personal things that I've seen, and some of them hopefully you remember. But I don't know what year it was that the Penn State guy that had set up the program for young boys to have a sports thing. You remember that? What's
I
that
don't
guy's
remember
name?
that.
Somebody remember? Somebody help me.
Jerry Sandusky.
Jerry Sandusky. Thank you,
I
Stacy.
remember that.
Yeah, so Jerry Sandusky, they totally covered it up. I know situations, it wasn't a child sexual abuse, but I know at Vanderbilt they had some issues with covering up sexual abuse within, just the students and stuff, and how the sports guys had, this was a big case in Nashville where we had a big, huge sports person in a student, but a big football player who had sexually abused, and how much effort Vanderbilt went in to cover it up. So that'll be really interesting how far this goes into foster care, into group homes, into Boy Scouts, of course, a Boys Club of America had a big lawsuit. Girls clubs had a big lawsuit against them in Tennessee. So. And let me tell you this. Listen to this one. I had a lawsuit against Williamson County Detention Center in Nashville because a child had been sexually assaulted in detention by an employee. And only because it was, they did everything to hush that and make it quiet. And only because we started shouting about it was that person suspended from their employment. So that is a brand new aspect of.
I'd like to stop you for just a second.
Yes.
And this is an aspect of us for child welfare in terms of that sex trafficking new provision. I was at a state level meeting with all of the to-dos, and we brought foster parents in, and there was almost every single one complained of the fact that they had a child who was sexually molested or raped, and the social worker would not allow them to report it.
That's what I wanted to bring up.
Yep.
And it's all over the news.
And that happens all the time.
They feed the kids to pedophiles.
Yeah, well,
in Florida they do.
Or if the child is molested, they won't let them report it, because then the social worker gets in trouble, or it's more paperwork.
Okay,
or
wait a
whatever.
minute. So who's doing the abuse? I hope y'all can hear enough
So-
of this. We're having.
Yeah, we can hear.
Okay.
The
We can hear.
pedophiles become foster parents
Oh.
to get kids.
Pedophiles become foster parents
that
to get
happens,
children.
but at the meeting
And
that
adopted.
I was at Washington State level, what was happening is that the foster parents who were there, and there were about 12 of them, we went around the table and they said, this is my most pressing concern. And most of them had this as a concern. They had a child in their care that was sexually molested or raped.
Right.
And they did report it to the social worker, who would not allow them to report it to the police.
Okay, so
Oh.
but who molested the child? The
A
foster-
variety of different things with this
Yeah.
one. Like usually it's a fellow foster child.
Correct. Okay.
And-
Yes. Correct.
And another thing
So we're
is,
talking about foster on foster sexual abuse.
whether this is a law or a policy that the sheriff came up with in North Florida, they decided that they're not gonna criminally investigate child abuse anymore. Only CPS is, and CPS cannot prosecute anybody.
Oh my
Isn't that
this is
insane?
so horrid. I don't even.
So
I
that
don't
means
even know
no
where to go with that.
abusers are gonna go to prison. Because there's no criminal,
Repercussions.
yeah. And only, but the other part, I just wanna mention about this, they found a pedophile or whatever. Turns out he was a foster parent. And he told his wife, oh, we need to get some more foster kids or whatever. But then the USA Today did a bunch of news reports where they were like feeding a child sex offender kids after knowing he was a child sex offender.
Right.
And they kept feeding him the kids. So I literally think it's their business. So are you saying that this is a federal oversight program for the state-run sex trafficking rings?
Yeah. Exactly.
No, is it?
It's
This is-
identifying
Well,
other organizations that you don't normally look
Hold
at
on.
as
Hold on.
sex
Maureen wants to
trafficking.
say something. Yeah. Go ahead.
We have a hand up by Janelle, and I know she's there with you. Does she want to ask a question before you move on?
She's over at her house.
She's over at the other place, but she can ask a question.
Yeah.
Go ahead, Janelle.
Okay. Go ahead.
I was just gonna say that I had a friend named Wendy that was in how you say this? She was getting molested, and her mom, they had 7 kids, but her dad was rich, so he had money, and they would never listen to her when she told them that her dad was raping her.
Yeah, I know.
And then when her dad was raping her, she complained to the school. She made all kind of terrible noise. It was the craziest. And they took her away from. Well, no, she made all kind of noise, but her mom took them away and went into a 2-bedroom with 7 kids. Her mom turned around and told them why she did it, why she took her kids, and they said, "Oh, this man got money. Your husband got money. He can support them, and he can do this and that." And so they took him from her because she was living in a 2-bedroom with 7 kids,
Yeah,
and gave him back to him, and he
Wow.
continued to rape them.
yeah, I know.
And
Yeah. Okay.
Wendy couldn't understand it. She was like, "Why you would give me back to my dad when he kept doing this to me?"
Yeah.
And he kept on raping her, kept raping her, and kept making noise, and they finally came and arrested him, and
Okay.
he in jail.
Yeah. Okay.
But what they did is that when they gave her to a foster parent, they ended up beating her and mistreating her, and they warded her to the state when she got 18 years old.
Yeah.
Why
Okay.
do they keep warding kids to the state at 18 years old? To
Okay,
shut them up
okay,
or
Janelle, we're trying to get into this CAPTA bill, so let me go ahead and move on with this. Okay, so the next section in CAPTA is about forced child marriages, which is also a new section to CAPTA. And it says that the state, the secretary, which whenever it says secretary, it means the secretary of HHS, Health and Human Services in DC, the federal agency, shall do a study regarding the minimum marriage age and the prevalence of marriage involving a child who is underage of such minimum marriage age. Now, I think in Tennessee, our minimum age is 18 unless you have specific permission of a parent. I think you can get married at 16, but that's the minimum age. And under that, you have to have like judicial authority. So they're looking at, and then there's a whole a separate section of that which says, and part of the study is to include to the extent to which statutory exceptions to the minimum marriage age are in such laws contribute to the prevalence of marriage involving a child described below, and whether such exceptions allow such child to be married without the consent of the child, which is arranged marriages basically, right? So looking at, it's kind of interesting to me. It's like, how did this get into CAPTA? You have to ask yourself that, right?
Yeah.
Huh?
That's a good question.
Yeah.
So what are they saying? They're really considering non-consensual marriage?
No, they're against it, I'm sure.
Well, they're again. I mean, this is for the states to do a study on
Right.
that impact.
They're acknowledging that it's happening,
Yes.
basically, and they want to see how much it's impacting people.
Right.
So,
Go ahead. Did you have a question on that?
No.
All right. Let's move on to monitoring oversight, written guidance, differential response. All right. So then under a section monitoring and oversight. Yeah, I want to. Okay. So this one talks about just really improving the. Okay, this is about infants again. Hang on here a second because this is important. Okay, so include written guidance and technical assistance to support states. So when it says written guidance and technical assistance, it means that HHS is to write a technical assistance guide. Now, these are actually pretty important. They don't have the authority of law, but they are recommendations by the federal agency to the states on how they operate. The one that is most compelling that I have come across is the one on parents with disabilities. The Sarah Gordon case, there was a report on that out of HHS and the DOJ, and then about 4 months later was a technical assistance on handling parents with disabilities. So hopefully, so when they say technical assistance and written guide, that's a good thing for us. And this one is to support states which shall include guidance on the requirements of this act with respect to infants born with and identified as being affected by substance abuse and withdrawal symptoms, neonatal substance abuse, fetal alcohol syndrome disorder, and then saying that addressing state identified challenges in developing, implementing, and monitoring safe plans of safe care, and disseminating best practices on implementation of plans of safe care on such topics as differential response, collaboration and coordination, and identification of the delivery of services for different populations while recognizing the needs of different populations and varying community approaches across states. Okay, so interpretation, what this means to me, again, this is an important thing because so many babies have been ripped away out of the hospital, 2 days old, 4 weeks old, all of them like under 8 weeks old, right? And so this is again kind of drawing that tension to, can we have a differential response, or are the states going to be mandated to have a differential response and do a true assessment of safety before they go and rip these babies out of these mama's arms? So that's an important thing for me with what I see, because and most of you probably know this already that are here, but for other people listening, there's 687,000 kids in foster care, and 85% of them are there under what's termed neglect, not physical or sexual abuse, and half of those children are there because of some type of substance abuse allegations. So we know that if we could better address the substance abuse, we would reduce foster care by almost 30%, right? Mm-hmm. So I think also yes, go ahead.
I was just going to add to that, and we also know as a nation and an addiction community that 85% of those who are engaged in substance use disorder activities have unaddressed early childhood trauma that was either never diagnosed or misdiagnosed, or grew up in an abusive home and never actually obtained any kind of effective treatment for that early trauma experience. Hence, they now use substances to self-soothe and self-medicate, which turns into a physical addiction.
Absolutely. All right, so another section which is talking about a working group to create some recommendations. It says the feasibility of making publicly available on a website of each state definitions and standards of substantiated child abuse and neglect for this state. Is there a bottle of water over there? You can have. Now this is, again, this is important to me because here's what happens is that CPS comes and starts an investigation on a parent, and the next thing you know in Tennessee, they get a little letter in the mail that says you've been substantiated for abuse or neglect, right? And it doesn't even say for what, right? And so then you have to start the administrative appeal process. And the definitions of what they define, especially as neglect, are extremely broad. Psychological harm, psychological abuse and neglect in Tennessee is basically whatever they want it to be. It can be a one time. I had them allege that a parent was psychologically abusive because her teenage daughter had made a false allegation of sex abuse against another child in the family, and a parent said, if you're going to make false allegations, you can't live in this house. And that was considered psychological abuse instead of confronting the child over their own misdeeds. So the psychological abuse and neglect section is just way overly broad. So this is just saying we're going to put it out there so people know what it is, which is probably a good idea. Because people have a lot of misconceptions too. Some people believe that you can spank your child as long as you don't leave a bruise. Well, I don't know. I don't know where that came from, but basically hitting a child is considered abuse and neglect. So, yeah, you don't have to leave bruises, just telling you. Let's go on. Now, they have a section here for community-based grants for the prevention of child abuse and neglect, Kathleen. It says to establish and maintain support for community-based family strengthening services and statewide system building approach to the extent applicable to ensure the development, operation, expansion, coordination, and evaluation of quality services, initiatives, programs, and activities to prevent child abuse and neglect, to promote improved access for diverse populations with demonstrated need, including low-income families, racial and ethnic minorities, families with children or caregivers with disabilities, underserved communities, and rural communities, to family strengthening services in order to more effectively prevent child abuse and neglect. So this is just a whole section about really trying to expand the community-based grants. And again, they've got that important word in there for me, which is family strengthening, which is new. This is a brand new word.
When I was there, sometimes I said, well, so hope.
We have a hand raised. Crystal has her hand up.
Okay, can you hear me?
Yes.
Yeah, okay. So, because I'm the one that had problems with connection. My thinking about just family in this, it's not descriptive. So, DCF, CPF, whatever, can say, well, we're working with, foster families. We're working with adoption families, but not the biological families or the original placement or original home for that child, because some kids live with their grandparents or aunts or uncles, whatever. So it needs to be more descriptive.
I agree with that. We had a problem in Washington where they was trying to relabel foster parents as parents.
Replaceable.
Yeah, they were trying to recategorize
We have that
them.
problem in Connecticut as well, and right now I'm aware of a case where the grandmother was the predominant caregiver because the daughter had a low IQ, and the department is moving forward as if the biological mother is in fact the mother, therefore the family is impaired, and in this particular case, the grandmother had always been the primary caregiver, but she's not looked at as the family, she's looked at as a grandparent with no rights. So it would be good if we can give some thought and opinion to family description and how it needs to be woven into maybe what we do moving forward.
Okay, so, yeah, go ahead.
Are we discussing this because we have an opportunity to change it? Or?
Okay, yeah, we'll come back to that. Okay, so, but I will say, and somebody might, I don't know, everybody's on their cell phones, I think, but if somebody who's not on their cell phone wants to look up the definition of family under CAPTA, because this is a amendment to CAPTA, so it doesn't have the definition section in it. I will say that frequently in here, they use parent and child. So I think under family, you're probably going to find the definition under CAPTA is parents, the biological or legal parents of the child. So it could be adoptive parents, but I believe it's going to be the legal or biological parent of the child.
Okay,
Did you find it?
no, I want to say something about trying
Okay.
to use this. Yeah, in the Right to Lie video that she always posts, they argue that the case law. Oh, it's right.
Okay, wait a minute.
Okay.
You need to turn your.
Okay.
Yeah, just sit here.
Okay. Oh, hi. In the Right to Lie,
You need to mute yourself on there.
your microphone is muted.
Okay, just turn it volume down then.
Oh,
Just turn
okay.
the volume down.
Okay. The case law, they made case law. I don't know if it's in every state, but they claim that the foster parents are equal. They're the replacement parents, so they consider non-biological foster parents. That's why they say you can't sue them. They're not. You can't sue the state as you do when police hold people in state custody, because they're like, no, the foster family is a replacement family, and that's federal.
Okay.
And then they argued in the Right to Lie case that Kathleen always posts, that they were arguing, well, no, the foster family is a comparable replacement to the biological family, so they do consider that the family. The second thing is, if this is negotiable, there should be a line of custody to where kids go to within the family first before they go to the state.
Yep.
And you wrote that one
Yeah.
paper to do
Advanced
that.
directive.
Okay, so a couple things, so I'll address. So there's lots of legal arguments in the Right to Lie argument part of it, where they talk about that. But I mean, foster parents don't have federal civil rights as it relates to children, so they are not the legal or biological parent of the child.